Let's say a police officer is legally searching your house and sees something that she thinks might be a stolen item. Under the plain view exception to the Fourth Amendment search warrant requirement, a warrantless visual search is admissible if it's conducted from a lawful vantage point. Without a warrant, the officer also can seize incriminating evidence seen in plain view. But can the officer physically move the item to confirm its incriminating nature before seizing it? Or must she first establish probable cause to believe that the item is incriminating? The Supreme Court addressed this question in Arizona v. Hicks. In Phoenix, Arizona, a gun was discharged inside James Hicks's apartment, injuring a person residing in the apartment below. Police officers were called to the apartment building. After conferring with the shooting victim, the officers went to Hicks's apartment. Without a warrant, the officers ordered the apartment manager to let them inside Hicks's apartment. Once inside, the officers found several firearms located throughout the apartment. One of the officers, Officer Nelson, also noticed expensive stereo equipment inside Hicks's otherwise squalid apartment, which was littered with evidence of drug use. In view of the nature of Hicks's apartment and the presence of several firearms, Nelson developed reasonable suspicion that the stereo equipment had been stolen. He decided to check the equipment's serial number to determine if, in fact, it had been reported stolen. In order to expose the serial number, Nelson had to move the equipment a few inches. He then called the police headquarters to determine whether the serial number had been reported stolen. When Nelson was informed that the stereo had been taken during a robbery, Nelson seized it as well as the firearms inside Hicks's apartment to use as evidence against Hicks. Hicks was charged with robbery in state court. He moved to suppress the evidence that Nelson had seized from his apartment without a warrant. The trial court granted the motion. On an appeal by the state, the Arizona Court of Appeals affirmed, and the Arizona Supreme Court later denied the state's petition for review. The state then successfully petitioned the United States Supreme Court to review his case.